Hello and welcome to Law Kanya. In this series, I will discuss about legal developments that took place in country during previous week. Let's start with Supreme Court updates first. Absence of motive in a case depending on circumstantial evidence is a factor that weighs in favor of the accused. The Supreme Court has reiterated. The bench restored the acquittal of two accused, Anwar Ali and Sharif Muhammad, by setting aside the conviction recorded by the Himachal Pradesh High Court. The duo were accused of murdering one Deepak. Now, in this case, Rajinder Kumar was employed as a driver by Beli Ram. The former met with an accident while driving a truck owned by the latter. He filed a petition under the Workmen's Compensation Act 1923. The commissioner passed an award directing the insurance to pay compensation towards medical expenses and injuries suffered. Interest was directed to be paid by the employer. In the appeal, the High Court absolved the insurance company of any liability on account of there being a material breach of insurance policy, inasmuch as the driver's driving license had expired at the relevant time. The question of law considered by the apex court was whether, in case of a valid driving license, if the license has expired, the insurer is absolved of its liability. When an employer employs a driver, he has to take reasonable care to see that his employee gets his license renewed within time, the Supreme Court has observed. The Supreme Court has observed that the precise time when the Gazette is published in the electronic mode is significant for determining the enforceability of the notifications. The bench comprising D.Y. Chandrachud, K.M. Joseph and Indu Malhotra observed thus, while upholding a Punjab and Haryana High Court judgment, which allowed the writ petitions filed by various importers. Following the terror attack at Pulwama on 14 February 2019, the Government of India published a notification on 16 February 2019 in exercise of powers under Section 8A of the Customs Tariff Act. The notification introduced a tariff entry by which all goods originating in or exported from the Islamic Republic of Pakistan were subjected to an enhanced custom duty of 200%. The precise time at which the notification was uploaded on the e-Gazette was 20 hours, 46 minutes and 58 seconds. The PIL was moved by the National Alliance for People's Movement and its convener activist Medha Patkar, seeking quashing of the decision of high-powered committee to the extent of clause 3, 4 and 6. As the High Court refused to quash the categorization, the NGO approached the apex court. The committee has classified inmates of prisons into three categories, that is, the first, under trial prisoners, convicted persons who are facing trial or convicted to the maximum punishment of 7 years or less. Second category was the convicted person whose sentence is above 7 years. And the third category, that is the under trial prisoners or convicted person who are booked for serious economic offences, bank scams and offences under special acts. And those above maximum sentence is above 7 years shall on their application be appropriately considered for release on emergency parole if the convict had returned to prison on time on the last two releases, whether on parole or parole. The court within whose jurisdiction the branch of bank where payee maintains the account is situated will have jurisdiction to try the offence if the cheque is delivered for collection through an account, noted the Supreme Court while dismissing a transfer petition. In this case, Haryana Self-Farming Group had approached the apex court by filing a petition under Section 406 of CRPC, contending that under the delivery challan, all disputes between the parties are made subject to the jurisdiction of courts in Siliguri, and that when the group has its head office in Siliguri, There was no reason to lodge the complaint at Agra except to harass it. The court also said that if the delivery challan, which states that all disputes will be subject to jurisdiction of courts in Siliguri, is construed by the petitioners to constitute a bar on the court in the other jurisdiction to entertain proceedings. It is always open to the petitioners to raise this point before the Agra court. This cannot be a ground for seeking transfer, the court added. Upholding this view, the apex court bench observed that the categorization by the HPC cannot be considered as unreasonable, and that exclusion made has a reasonable basis and cannot be termed arbitrary. The court said that the methodology for grant of interim bail is with the intention to avoid overcrowding in the unprecedented circumstances, and the grant of bail in the present circumstance is an additional benefit to such person. Now let's move on to High Court updates. The bench of Justice V. Kameshwar Rao was hearing a plea filed by an ex-director of the company Alibaba, praying a quash complaint case number 2863 of 2019 and others. Now this case relates to Negotiable Instrument Act. In short, this petition was filed seeking the quashing of 5 complaint cases initiated by the respondent against the petitioner. These complaint cases were primarily grounded on the return of 5 checks which were issued on behalf of other respondent for a total amount of Rs 45 lakhs. The Delhi High Court ruled that a person who has retired as the director of the company cannot be said to be in charge and responsible for the conduct of day-to-day affairs of the company, as contemplated in Section 141 of the Negotiable Instruments Act, for being proceeded against. In this question, whether traditional values and general moral policies could determine and expand a scope and ambit of a piece of legislation to bring in consequences which even the lawmakers would have not contemplated or intended, a full bench of Kerala High Court has expressed its doubt. The bench observed that while considering a reference which involved interpretation of the Maintenance and Welfare of Parents and Senior Citizen Act, the court noticed that to give an expansive interpretation, a single bench judgment had preferred to the religious and philosophical text to highlight the traditional value system. If you found this video useful, like and share with others. Also, make sure to subscribe to this channel. It's absolutely free. Thank you for watching this video.